Welcome to our preview of our 2025 DC Bar Changing Currents in Employment Law, the DC Bar's 3-hour fast-paced fall CLE that previews cutting-edge topics in employment law from both sides, the management and employee side perspectives. I'm Scott Oswald, Faculty Chair of Changing Currents in Employment Law, and I'm joined by Tom Spiggle. He is the founder of the Spiggle Law Firm. Tom, you're speaking on a panel entitled Post-Employment Restrictive Covenants, a primer on the legality under local law. You'll be focusing on the validity of post-employment restrictive covenants in DC, Maryland, and Virginia. Tom, hello.
Hi, Scott. Thrilled to be here.
Well, so happy to have you here. Hey, introduce us to your co-panelists and some of the key things that attendees at this year's Changing Currents in Employment Law can expect to learn from your panel.
Absolutely. Well, yeah, I am honored to be joined by Linda Jackson, who is a longtime employment attorney, management side. She's a partner at ArentFox, who has done, I won't even try to list her many accomplishments, but she is a superstar in this field, knows what she's talking about, and I'm thrilled to be on the panel with her.
So give us a preview, a teaser of some of the topics that you and Linda will be reviewing during your panel.
Yes, absolutely. I mean, just as you mentioned, we're going to be talking about restrictive covenants and how they vary from state to state. It's the creatures of state law in many respects. And so there are some important differences between, Maryland, DC, and Virginia. So we'll be talking about those and how the different jurisdictions vary. Linda's also going to be talking about the federal overlay and what's happening. We had the previous administration some pretty active work on, particularly on non-competes, and she'll be talking about that and where that stands today.
So give us a little bit of a sense of the advice that you're giving to clients who are coming to you with post-employment restrictive covenants that include DC, Maryland, and Virginia law.
Yeah, it's a really vital for my clients, all the way through the representation, really, because as you probably know, sometimes it can become the tail that wags the dog. And if you don't get out in front of those things early on, because these are not really aspects that most people who are not lawyers and even lawyers are really up to speed on. And so to advise folks on, the real important impact of what a non-compete could mean for their career, similarly, the non-solicitation, non-disclosure. I mean, these provisions have real teeth. I mean, for my clients, it's important that they understand that going in to the representation, and also when the final signature is on the resolution of the case, I want to make sure that they are well aware of what their rights and responsibilities are.
So just in terms of your own view, where do you see this area of law headed in the near term?
Yes, I think we're going to see some more divergence at the state and local level, particularly with the federal government sort of stepping out of the fray on this in many ways. We're seeing states and DC go their own way and coming up with their own provisions, their own pieces of legislation. And I think we're going to see more of that. So I think it's really important for folks who are practicing in these various jurisdictions that you have a sense of where they are and what the distinctions are, because it can be very different between the three. And if you've got a client in Maryland, it can be very different than one in Virginia. And I think we're going to see states, not only in the DMV, but nationwide, continue to kind of chart their own course on these issues.
Tom, thank you. I look forward to seeing your panel in October, and I look forward to seeing each of you on Tuesday, October 28th at 5:30 p.m., beginning with our reception for our in-person attendees. You can register right now using the CLE tab at dcbar.org.